Welcome to the Immigration Lawyers Podcast. I am the host, Attorney John Khosravi, and I practice U.S. immigration law exclusively. For more information about the program, please visit www.immigrationlawyerspodcast.com. Please note that this recording is informational only and does not constitute legal advice. Please consult with a licensed attorney for specific legal guidance that suits your case. Also, this recording is copyrighted and written permission is required for rebroadcasting. For more information about me, please visit www.jqqlaw.com. Hi everyone, welcome to episode 54 of the Immigration Lawyers Podcast. It's a weekly episode covering August 7th to August 13th. Right off the bat, I wanted to get into the RAISE Act. So I downloaded the bill that the geniuses in the Senate produced, and it goes over a lot of the details of what they think the RAISE Act will be. As you all know, when you do immigration law, the amount of details to cover all the scenarios that happen would fill a whole encyclopedia. So this 40-page, and when I say 40-page, it's how bills are written 40 pages, which is like little sentences per line, which really, if you make a book out of it, it comes out to like 10 pages or less. But I wanted to go over it really quick, some notes on it, just so you have in mind. I don't think it's going to happen, and I think it doesn't really makes sense, but for example, one of the things that had come about in the bill is originally they said they're going to backdate and cancel previously submitted applications, but the way they do it now is they say any after this bill was introduced, which it was introduced a few weeks ago, any applications that happen during this period of time and that get done within a year of the introduction of the bill are okay. They're considered in the old system. But if it happens after that 1 year period of time, the people that would get the immigrant visa then go into the point system and get some special point benefits. So that's how that works. An important thing is they're going to change the age of adulthood for the purposes of immigration from 21 to 18. So that's a big hit on a lot of applications, and the whole CISPA system, that Child Status Protection Act, that existed that covered up to 21 years of age. Now it's 18. And they're striking out the benefits from U.S. citizens to parents and children. Essentially, they're going to leave it for spouses only. And they're also tweaking the numbers of immigrant visas available and adjusting it on the worldwide basis, on a per-country basis, and they're just changing a lot of that. Interestingly, they're creating what's called a non-immigrant classification for alien parents of adult United States citizens. So although they won't allow parents of U.S. citizens to get green cards anymore, they're creating this like 5-year non-immigrant visa that I think is renewable once for additional 5 years. The parents who come here, they can't get a green card or benefits like that. They don't have employment authorization, but they could stay here with the family for 5 years and extend for 5 years. The U.S. person has to have a sponsorship, a financial sponsorship, so something like an I-864 for it anyways. There's issues of, and they go into this a lot in here, making sure health insurance coverage is possible and people are either insured or they have a bond to be insured once they enter the United States. Now with regards to the point system for employment-based category cases, they go into some detail about how the point system works. So they're getting rid of all the EB-1 through 5 categories and giving points based on certain eligibility criteria, for example, English language skills, education, and other background factors. There's going to be the system is going to be like people could pay $160 to go into this pool where they could put their name in there and their specifications, and annually a certain amount of these people in this pool are chosen, and then they have to submit documents and I think pay an additional $220 fee for the processing at that time. Those who aren't chosen in that pool, and the pool gets like every 6 months they choose from it. If you're not chosen within a year, your case is canceled, and your place in that pool is canceled, and you have to resubmit. So it's going to be a great money-making scheme for the Department of Homeland Security, because a lot of people internationally are going to be paying into this, and the vast majority of them aren't going to see anything from it. But the DHS is just going to accumulate a lot of funds through the system. An interesting note is, for us lawyers and as well as doctors, we're considered having professional degrees, not doctorate degrees, for the purposes of the point system. So if you have a doctorate degree, you have the highest level of degree there is, and you get more points. A step down from that is doctors and lawyers and people with professional degrees, MBAs as well, and it just goes down from there. So it's interestingly, even though as an attorney you have a Juris Doctorate, as a MD you have a medical doctorate, that's considered a professional degree, and it's second to a person that has a regular doctorate degree. And when it comes to the point system, they also look at the age, and a person at 25 is considered the highest ranked age. Variations from that up and down diminish the amount of points they get, and people, I think, under 18 aren't even included. Now, when you're chosen in this pool system, you have 90 days to submit the documents you need to petition for things to move forward. So it has to happen fairly rapidly. And I think that's another way of cutting out people who are even chosen in the point system. Another set of them are going to get kicked out, and fewer numbers are going to be chosen and actually getting the immigrant visa. And I'm sorry, as a correction, the fee that you have to pay once you are chosen in the system to further processing is $345. And again, the insurance requirement is here of having health insurance or posting a bond until you get health insurance when you come in the U.S. And they have an interesting section right here for dependent adult children. It says, any adult child of an applicant under this subsection who is unable to care for himself or herself may be admitted into the U.S. on a temporary basis until they're capable of taking care of themselves. There's no work authorization included in this. So it's interesting that they have an adult child exception in there. And they reiterate the fact that 18 is the cutoff age for children, not 21. A final note is their update on the EB-5 program. Essentially, when the investment happened, that just adds to the points that can accumulate to rise on the top of the group that are chosen for an immigrant visa. So the lower amount investment is $1,350,000 to get 6 points, but if you invest $1.8 million, it's 12 points. The difference between this EB-5 category here is that playing an active role in the management of the commercial enterprise is required. And it's for 3 years. So you have to maintain an investment for 3 years and be fully active and have a role in the management of the commercial enterprise, as opposed to the current EB-5 regional center system, which is essentially a nominal limited liability partner doing one vote a year. That doesn't mean anything. Management system that they require. Here it has to be hands-on. Now, as you all know, with the EB-5 program, the limited amount of legislation and regulation there is on it, it creates a whole bunch of issues. And this will probably be the same as to what each and every word of this means, what active role is, how much investment has to be maintained, and all the details that go into it. It's going to be a hot mess. When you want to redo the entire INA, the essential parts of an Immigration Nationality Act, this just doesn't cut it. So I don't think this is going to happen. Initial bargaining position at most. But we'll see. If crazier things have happened, but I don't have faith that this is going to get very far. It's just going to alienate too much of the population currently for the legislator to actually move forward with it. But you know, it's interesting to see new things coming forward. There might be some ideas in here that are good or ways to make it simpler. Frankly, a point system might be easier for foreign nationals to get involved in the immigration process. As it is right now, it's very limited, near to impossible for most people to even get a benefit. And maybe the EB-2 or EB-3 categories do exist to help, but those have all sorts of difficulties within the PERM system. So it may be a better way to do it point-wise for the end client, maybe the way other countries like Canada do it. On the other hand, the limited number of immigrant visas available will make it very difficult for people to actually take advantage of it, because even if they are a good candidate, they're probably not going to be able to get picked in the lottery system. So that was a quick synopsis, relatively quick synopsis I wanted to put out there of the RAISE Act. I know I've talked about it before. I thought it's something important we talked about before getting to other stuff. Getting into the news. So there was a famous case of this one immigrant here who had deportation order out in their name that was in the U.S. They were going to drop off their kid at school, and ICE picked him up right there. And it made a lot of hubbub in the news, and it was pretty disastrous PR for ICE. And in general, it was very sad because it made people afraid to take their children to school or even go to school, because they saw that, you know, the school zone isn't a safety area for people to just go to. Luckily, one of my colleagues here in Los Angeles, attorney Alan Diamante, was able to fight the case and bring it back to the immigration court. And they essentially, I think they're going to file a U visa to continue the case and try to keep the parent here. Apparently in California, they readjusted the criminal laws that would affect the immigration consequences, and that adjustment could potentially allow this immigrant who's in this situation to find some sort of solution to their issue. But it was interesting that he was able to help fix that, and being in the news does help out in these kind of cases, especially when they're heartfelt and they're really punishing people in a very difficult circumstance. On the other hand, the article here from Fox News says the feds are offering possible change in visa status to persuade illegal immigrants to turn on MS-13. So I guess they're kind of an expansion of the U visa system or something, but ICE wants to go after MS-13, and they're giving potential immigration benefits to people that are willing to discuss that and talk about it and testify against it. They already have a system right now where they do that. I had a client that got it actually, a deferred action or prosecutor discretion, where ICE will give like 2 years and an EAD card if you're a witness to a crime, and they can keep you here. So essentially somewhat of a U visa, but for crimes that don't reach the U visa level. So that's something to know, that your clients have that option. But frankly, if my options were to leave the U.S. or to get a temporary benefit to testify and be a witness against MS-13, I'm not sure if I would take those benefits, because the consequences of the repercussions of revenge from that group are going to be much stronger. On the EB-5 side, there were finally a couple people went to jail for the fraud that they did in the EB-5 program in their projects. So that was interesting. Earlier this month, a guy named Lobsang Dargay, a former claimed to be a former Tibetan monk, was sentenced to 4 years in prison for crimes as part of a plea agreement. The guy essentially was trying to steal millions of dollars. So there was another arrest as well that happened. It's good to see these people going behind bars to clean up that system. But whenever there's that much money, there's going to be a little bit of fraud that comes along with it. CBP has increased its deployment of exit technology at airports, so I think it's like a biometric system. Although they're adding it to airports like McCarran, Las Vegas, and in Houston, they're limiting it to like single flights out to certain locations. So it's a small fraction of flights going outside the United States that they're doing this for, but it's a pilot program. And pretty soon I think they're going to institute it everywhere if the funding allows it. It seems like something they've been wanting to do. It's been legislation already passed that they're supposed to be doing this. So that's going to be happening. I've had people call me in the past where they were leaving the U.S. and overstayed here, and they're afraid of leaving because CBP might catch him and hold them here because they overstayed their stay. And I would tell them, like, don't worry, there's no exit procedure. But now I can't say that. I just have to tell clients to be mindful. There's the other issue of traveling in the United States, having proper ID now when you travel. So if you are here unlawfully, I guess with your foreign passport you could travel, but with state IDs, I think there's 10 states that haven't updated their ID system for the Real ID Act. Those groups of people will need some sort of ID that's sufficient for even internal travel within the United States. And there's always a worry, if you're here unlawfully, traditionally it wasn't a problem traveling with the United States, but in the current climate, either flying or even driving across state boundaries is something that might pose a risk. I've had clients want to go visit family in Texas, or not clients, but people who ask me and consult me. And I say, especially if you're going to Texas, I wouldn't do that. But if you're here unlawfully, just stay put. Don't rock the boat. It's already risky enough as it is. Maybe just wait another 3 years and 6 months until the new administration comes in. The reason why I say that is the Department of Justice has said immigrant removals under President Trump have jumped 28%. So we already had a large number of removals happening under the previous administration. Now under Trump it's up another 28%. So that fear is real. The situation in the courts is real. They're tougher. They're taking away prosecutorial discretion in a lot of cases. Administrative closure isn't necessarily happening. So the fear is real. There's, I talk with people about the reality of, can the immigration system be changed? I don't think it can, because the system is so ingrained and so complicated that you either have change the whole thing's not going to happen, and changing individually is going to have too much pushback. So the executive can't really do much other than the stuff that was like on the ends of things, but that still affects a lot of people. So really getting harsher in their execution of the executive branch duties in immigration court could be made harsher, which is what they're doing. Cracking down on CBP and being tougher, consulates being tougher. These are things where the law isn't that solidified, and there leaves a lot of leeway for people to put pressure on the foreign nationals. So those are the areas that have gone tougher, and it's affecting a lot of people. But I think the core of the immigration system can't be changed as it is, even under the president, unless you have some sort of extraordinary events that happen that create the public atmosphere and mood to make change. And these things do happen. So far, I haven't seen anything that would cause that, and it would have to be something very big and extreme to happen. The things that have happened have really frustrated me with the immigration USCIS benefit system are the delays that are happening. I mean, I've talked about the EAD situation where people are getting their EADs after they get their green card or not even getting the EAD, which is very frustrating because clients really want to get that work permit so they can get their social security number, and it's not happening. Naturalization is taking months and months and months. It's taking so much time, around 8 to 9 months here in Los Angeles. I-90 approvals for green card are random. It could take more than 6 months, 8 months, 9 months to get a typical green card just renewed. And even I-130s for parents of U.S. citizens, I used to get these done in 4 months, 5 months. They're taking 7, 8 months now. I've got a couple pending. And the clients are getting very frustrated and worried. So I'm spending so many more hours. I think I spend at least 2 to 3 hours a week from clients that are calling and emailing me worrying, why isn't my case happening, and explaining to them it's not me, it's just immigration. USCIS is taking a while, your case is okay. With regards to EADs for marriage cases, my clients are requesting, please request an expedite, please request an expedite. I'm like, first of all the expedite requests I've had this in the last 3 months have had no response. I fax them, email them, and they just tell me wait longer, and eventually we get the green card without the EAD. So doing the expedite is, at this point, is really worthless. In February I did one and it worked really smooth, but after that everything went downhill. But when my clients beg for it and I do it, it takes time. It takes like half an hour to write the letters and organize a client, call USCIS, fax them. It's closer to an hour of additional work, and I'm doing 3 hours of extra work dealing with just the delay factor. And this is time I haven't put in my schedule, but I have to add on top of that to be able to do this. And when my clients call me with a flat rate system, I don't charge them extra. I speak with them, and I want them to know I'm here for them, so I never calm them down. But when you have constantly clients happening, if there's 1 or 2 here and there, it's fine. But I have 3 or 4 a week happening, and it's bad because it takes a lot of time. But even worse than that, for me, it's my reputation goes bad because they think oh, I did something that's causing my case to work faster because their cousin last year did it and it happened faster. They don't take into consideration the fact that everything is different from last year. Every day in immigration is different, every case is different, and it's all sorts of factors. Your cousin may have lied to you. Maybe it took them 8 months, but they don't remember, they say 3 months. So all these factors happen, but it makes my reputation look bad for something I didn't do. I obviously tell them at the consultation that USCIS is not something you could rely on necessarily to finish things within the timetables that they say they will. But 1 out of 5 cases might have this happen. Most of the time they're okay. And I tell them, but they forget that once the process starts. So I have to speak with them, make sure they know I'm there for them. If nothing's wrong with the case, and it's going to work out. And it does. But again, your reputation goes bad when these kind of delays happen. Now I want to get into some AAO decisions that came out. These are going to be employment-based cases, so if you don't handle those, it could be interesting. Two really neat AAO decisions on the EB-1C multinational manager green card category came out. EB-1C is essentially L1 that turns into a green card. One of the main requirements for the EB-1C is that you have been employed for a total period of 1 year before coming to the U.S. or in the last 3 years, really. So you've employed abroad for 1 year. It's not a continuous year. It's just 1 year of the last 3, and that in their qualifying position abroad. Now there are situations where people come to the U.S. on an L1 and they're here for 2 years, then they file for the EB-1C. The typical question is, well, what happens when you start counting that 3-year period? In reality, its 3-year period starts before you enter the United States on L1. But there are 2 cases that came out in AAO, and they specified in more detail how to calculate that period. The first one is called Matter of AS A-S Inc. From July 19, 2017. And in this case, the green card applicant had an L1A Canadian, came to the U.S., but would come intermittently. So they come to the U.S. very brief period of time. And for most of that L1 period, they were in Canada working over there and getting paid over there. Essentially, L1 wasn't an appropriate visa at the time because they weren't using them in the U.S. enough. Eventually, they do come in L1 and just stay here consistently. And they file for an EB-1C, and it gets denied initially because the USCIS says the 3-year period started when they got that first L1 that they were using intermittently, which was many years in the past. And so it was too late for them to use the 3-year history working abroad. The AAO said that actually, and it's actually a non-precedent decision, but they should make this a precedent decision. So there's a process for that, but that's something important they should do. But they say that the cutoff date should be when they came in on the L1A and officially stayed here for a long period of time. So if they got L1A intermittently and they're working overseas for that company, and you have the facts to follow that, you don't need to count the 3 years from that initial L1A. It's from the L1A where they officially came and stayed here and they were here. So I think it's going to be fact-based a lot, but it's an interesting case. If you had a situation like this, you can definitely use this. The second AAO case was matter of S-P-Inc., July 27, 2017. In this case, a person came here on an L1A after working abroad for the same related company, worked here for a period of time, and then switched and got a non-immigrant visa for another unrelated company, and then wanted to get an EB-1C from the first company they had the L1 for. So they were saying the 3-year history before they arrived from that initial L1 should be counted, but AAO said no. Once you switch to that other company, the 3-year period counts from the 3 years before that company. So because of the amount of time they were in the U.S. working, they pushed themselves out of that 3-year period. So they weren't qualified to use the 3-year history, so they have to go back to the home country, work another year, then come back to that L1A company. It might be easier to draw this one out than to talk about it, but essentially the point is this: you can't come in here on L1A, get another non-immigrant visa, work somewhere else, and then come back to the L1A and still use the 3-year period starting from the initial entry time. It gets adjusted and you lose the period of time you were outside the U.S. So I don't think this fact pattern happens too often, because what would happen? So you come to L1A, then you switch maybe to an H1B. I don't know how often that would happen, but I guess that could happen. In that scenario, you lose out on using the 3-year history. There are 2 other cases briefly I want to talk about. One was an EB-1A extraordinary ability case where a person was a co-founder of a mini electric grid development company. Now this typically would be a national interest waiver kind of case. That's what I would have filed it under. It isn't the typical extraordinary ability, but they did extraordinary ability EB-1A, initially denied by the director at USCIS but approved at the AAO. There are a couple of interesting points on this. One is they probably did the EB-1A because it's faster with premium processing, so that was the way to go, which I understand. National interest waivers can take a while. The case is matter of NKS ID number 430647. One interesting point is the job title they had put for this category was Field of Management of a Startup Focused on Renewable Energy. The USCIS said that this was too vague and should be narrower. But AAO, they said, no, that makes sense. They're managing a renewable energy company. That makes sense. And the person had articles written about them. Apparently, they didn't name the company, but it was a major company, and they were a major person at a major company, and that kind of stuff. And the EB-1A got approved. So that was a really interesting case. Kudos to the attorney who filed that. Maybe they did an NIW and EB-1A at the same time to see which one hits. That's the way I would do it, especially if I have the funds for it. But that got approved. So, EB-1A isn't necessarily athletes and actors. You can go far wide. Even the academic kind of fields, not stuck with the NIW. EB-1A is possible. Frankly, I prefer EB-1A because the criteria is more explicit, even though it's a higher standard than the national interest waiver. But the new national interest waiver is much better. Again, for this type of case, the national interest waiver is perfect. It's just too much of a delay for it to go through, especially if they're from India or something like that. It's going to take much more time. Finally, with regards to the AAO cases, and this was just ridiculous, but an applicant filed for an EB-2C national interest waiver, and the job category that they're seeking a national interest waiver for was a legal processor for the DA's office. This drives me nuts that people pay, or maybe attorneys take on cases like high school teachers for just general high school teachers, or here, a legal processor for DA's office for a national interest waiver. I mean, what are you thinking? That's obviously going to be denied. The case was denied. The legal processors didn't even have the educational requirements to meet the initial starting qualifications to go into the matter of Donisar analysis. So that was denied. I don't know what they were thinking to go and actually appeal that decision to the AAO, but it does happen. So there's some attorneys making a ton of money filing these ridiculous cases, and I wish the system would get cleaned up when we kick these people out, because it's putting false hope into people and wasting their money, and frankly clogging up the immigration system with cases that just shouldn't be filed. I understand some long shot cases, but a legal processor for the DA's office, that's the national interest. I mean, come on. Okay, so going just about some office thoughts I had. I'll leave one of them to the end, but two things. One is I was watching this thing on the news or some Facebook video that popped up. Apparently in Florida they have these pythons that are very scary, humongous snakes that are just choking up livestock and attacking people, all this kind of stuff. And the wildlife and the government entity, Fish and Wildlife, whoever it is, have tried tracking these, and they had a difficult time doing it. So the article said that, or the video said that, they went and brought two of these professional snake trackers from this tribe in India who started snake tracking and snake catching from the age of 2. And they brought these Indians here. It was very interesting. They had like white mustaches and white hair, but they're really young. So it's kind of this like guy from WikiLeaks kind of look. But these are some tribal village people from India. And they came and they were like catching these pythons like nothing. So that was interesting. Then I thought, what kind of visa did they get to come here? They said they're here for 2 months. Fish and Wildlife asked them to come, so it was like a government entity. I don't deal with these kind of visas. There has to be some sort of non-immigrant visa for these specialty situations, but I didn't really do the research, but nothing popped up in my head to cover it. So if you know what kind of visa a snake handler that's coming from India for a 2-month period at the request of a U.S. government agency, what kind of visa would they have? Please email me. It's info@jqqlaw.com, info@jqqlaw.com. It'll be interesting to know because this kind of stuff has to pop up in our practices over the years once at least. So it's good to know what kind of visa are necessary for these short period specialty need kind of stuff that don't fit within the typical categories. Secondly, I was looking at the naturalization requirements for if you're getting naturalized in 3 years based on marriage. And I was under the impression that once, you have to show that you're married to a U.S. citizen, you've been married for 3 years, and at the time of the application you have to be in marital union up until the time the case is adjudicated and you get citizenship. But I was looking at the adjudicator's field manual, and it says, the spouse of a U.S. citizen residing in the U.S. must have been living in marital union with his or her spouse for at least 3 years preceding the time of the filing of naturalization application. Okay, obvious. This provision requires that the spouse live in marital union with the citizen spouse during the entire period of 3 years before filing. Okay, that's the basics. However, the statute does not require living in marital union for the period between the date of filing the application and the date of naturalization. The date applicant takes the oath of allegiance. The corresponding regulation conflicts with the statute in stating that the spouse must have been married with his or her citizen spouse for at least 3 years at the time of the examination on the application and not at the time of filing. It says here, USCIS follows the language of the statute in requiring marital union only up until the time of filing. Accordingly, only the existence of a legally valid marriage is required from the date of filing of the application until the time of the applicant's naturalization. So essentially, you just need to have a marriage once we file, and then after that you guys can break apart and not be into each other, even probably initiate divorce, but as long as the divorce isn't finalized up until the application is approved and or ceremony happens, you're good. So, I mean, I don't know how, if someone is already in a relationship 3 years, they'll probably continue. The reason why this came up is I did a short video on this, and I said the person needs to be in marital union up until the time the application is in. But here it's just the legally valid marriage needs to be there, but the marital union could start breaking apart as soon as the application is filed. So these are super nuanced, but I kind of made a mistake in this other video I did, so I was like, maybe it's interesting to talk about. Finally, again, these weeks go by so fast and I'm so busy, I forget to take notes on all the interesting stuff I want to talk about. But this is a gripe I have with clients, and I'm sure you do too. And in particular, it's happening with my E2 cases, E2 treaty investor cases in particular. These aren't people that are necessarily business people who have companies. They're usually regular people that just want to come and live in the U.S. and have a small business. The problem with this one is that, once I have an initial consultation with the case and we get it started, they're like, okay, we're going to jump on there, we're going to do this investment, this and that, and then they go dark for a couple months, come back, give me all these documents, then go dark again, and then come back with the rest of the stuff I need, and they want it done immediately. And it gets very frustrating to do stop and go. And I want to see, do you have the same problems? It must be the same. When someone starts a case, they disappear, then they come back, they disappear, and something that should be done in a few months drags out for 6 months, 8 months, a year. It's very hard to put your mind into a very detailed, complicated case, to jump into it, then have to stop, and then forget about it for a month or two, then get back into it. it's hard to get that ball rolling again. It gets very frustrating. And I was talking to a colleague, and he said the same thing. His E2 cases, in particular, could last months and months or more than a year till people get their stuff together. Now, I tell my clients this from the beginning with this expectation. I say, listen, slow it down. This is going to take a while. Let's just do it. But they never listen. They just send a couple of docs, then they disappear. They don't at least keep communication with me so we know something's happening. But then when they give the documents back again, they expect it to be done like this within the recent case I got frustrated was like an hour of sending him. They expected me to do the whole thing. And things are still missing, but they're frustrated saying, oh, it's taking so long, it's taking so long. The reality is it's not taking so long because of me. It's because you're not giving me what I need. I can't build a house without any materials. So it's just a little frustrating thing that happens because I want to give the best service, but the clients don't really understand what goes on and what kind of attention is required and what kind of focus is required to do something that's so complicated. I mean, it's like doing surgery almost. So you can't just jump into it. You got to really think, because one wrong word could cause a denial at the embassy and a waste of all the funds and investment in their future. So it's just a little thing I have. Do you have that as well? I'm sure it happens with all of us in all types of cases. When I used to do things like removal or asylum or certain cases where the people were from low-income backgrounds who didn't access to email, who had trouble making ends meet, who had very troubled lives where they had to move a lot or they were living in fear, it was very difficult to keep a case going at a consistent pace. There would be times it would disappear for months, and all of a sudden they'd appear and be like, what happened to my case? And I'm like, well, didn't you see I emailed you, all this kind of stuff? And it makes it really difficult to be on a case when both parties aren't fully into it. Sometimes the lawyers aren't, and I've seen that a lot where lawyers disappear. But if the lawyer is into it, but the client isn't, it's just as difficult and frustrating to get something done in a reasonable amount of time and with the quality that you want it to. Because frankly, the more they stop and go, it burns you out on the case, and it's hard to focus on it. I mean, you have to, because at the end of the day, it's your job, but it does increase the burden of working on that case. So I wish there was a way to make that faster. We could work with clients, maybe describing the consultation what's expected, but they have their lives too and have their own issues and not necessarily going to go on the timetable that we expect. So that's something that comes up, and I have in particular 3 E2 cases that are stop and go for the last couple of months, and it just becomes like a frustration issue. Like, either let's do it or let's not do it, or at least keep me in the loop. Every 2 weeks or 3 weeks, send me an email, let me know what's happening so I can have in my mind what's going on in this case. Or when I request 5 documents and you send 2, don't get frustrated when things don't move forward, because I still need the other 3 that are missing. You guys have to be dealing with the same issue that I have. So that's just one of those things. Finally, to end it, I released an interview I did with attorney Peter Afrasiabi. Peter is a wonderful intellectual property attorney and very skilled in that area, has a top firm, but he also has a passion for immigration. And one thing he's done is he's written one and now his second book on immigration. This time the topic is about the history. I'll read the book. It's called Burning Bridges, America's 20-Year Crusade to Deport Labor Leader Harry Bridges. So Harry Bridges was this one guy accused of being a communist. They took him through the ringer, tried to get him out 4 times, 4 different court proceedings. Twice went up to the Supreme Court. Really just rode this guy to try to get him out. Done a lot of illegal stuff, lying on the stand, just abuse of power in the executive branch for sure, and partially in the judicial branch, and the legislature too, making up unlawful detainer, I think it is, or there's a term that they have for that. But really just hitting this guy. I understand there was a Cold War, they're afraid of communism, but you can't lose sight of your principles, and that was completely lost in this case. So it's a very interesting book to read. I had that interview I did with Peter Afrasiabi where he goes into more detail, and his book's available on Amazon. It was something interesting for us immigration lawyers to know, because you see how the situation works out when you have periods of time where people are afraid, there's financial, economic crisis, there's potential war or post-war kind of situation, and things will happen that you didn't expect. So it's good to be prepared, because we might be going through one of these moments. I hate to be a scaremonger saying this a lot, but as you see with the administration, the just insanity of what's going on, you don't know what's going to happen. So it's good to be prepared, and knowing the history will help you out a lot on that. If you can find his book on Amazon, and you can always contact him as well. I think his email is burningbridgesbook@gmail.com. If that email doesn't work, just email me, info@jqqlaw.com, and I'll connect you. I think that's the last thing for today. Thank you so much for listening. I look forward to the next week's podcast, and hopefully I have more of these in-between podcasts I can put out for your enjoyment. Thank you so much. Till next week, have a good one.